I often see people on our internet selling those business entity formation services, telling people that they can help them form business entities. They list corporations, LLCs, partnerships, and S-Corps. I also see tax or business influencers who tell people that they should elect an S Corp for their business entity for tax purposes without mentioning legal consideration. So there are two things that I want to clarify. First, regarding those business formation services, an S corporation is not a business entity that you form. It is a tax election that you select. And second, electing that status requires more than checking the box or form that it requires to elect it. There's federal law that sets prohibitions that an owner should know before making this election. So in addition to the tax benefits, there are limitations on S Corp status. And I want to go over a few of those limitations. Number one, the entity can only have one class of stock. Number two, the entity cannot have more than 100 shareholders. Number three, shareholders must be individuals. They can be in a state, or it can be in a state. It can be certain permitted trusts or specific tax exempt organizations, but it cannot be a corporation, a partnership, or one of those non-permitted trusts. None of these can hold a stock in an S corporation. Number four, stockholders must be United States citizens or residents. And finally, number five, the entity cannot be considered an ineligible corporation. There is a list of ineligible corporations, for example, financial institutions and insurance companies. Each requirement is a condition to make that S election. If a corporation makes that election and that corporation was not eligible on the first day of that first taxable year that the election was supposed to be effective, or if the corporation initially met the conditions, but it undergoes some type of changes later on that will cause it to lose its eligibility, the election will either be treated as terminated on the first day or when that change occurs, whichever one applies respectively. So if it is considered terminated upon termination, that corporation is generally barred from re-electing X corporation status for 5 years, and that's amongst many other penalties. So knowing that an S corporation is an election with prohibitions and not just an entity that someone forms for you or that just saves you money is what separates sound ownership mindset decision makers from just going with the flow thinkers. If you want specific guidance or consideration for representation, please view the bio or read the post description below on how to proceed with investing in your protection. Otherwise, I want you to keep learning from My Attorney Knows educational videos with the Ownership Attorney.